Question number 12, David Seymour.
Thank you, Mr. Speaker. My question is to the Minister of Commerce and reads as follows. Has he received any advice regarding regulatory uncertainty around peer-to-peer platforms and the Credit Contracts and Consumer Finance Amendment Acts 2014?
Mr. Speaker.
The Honourable Paul Goldsmith.
Yes.
Supplementary.
Order. Supplementary question, David Seymour.
Does the Minister support the Financial Markets Authority's interpretation that peer-to-peer lending platforms such as Harmoney provide an intermediary service and are not a creditor?
The Honourable Paul Goldsmith.
Well, I just say at the outset that the member will be aware that the Commerce Commission has civil proceedings to clarify whether one peer-to-peer lender platform fee constitutes a credit fee under the Credit Contracts and Consumer Finance Act, and so I don't want to go into the specific details of that. In terms of the broader question, yes, I've had advice from MB, FMA and the Commerce Commission, and I'm considering them all as to whether the overall settings are right, and I'll be working with officials and considering that carefully over the next few weeks.
True.
Supplementary question, David Seymour.
Why does the Minister think that MB and the Commerce Commission are concerned about a practice that is the norm for peer-to-peer platforms in the US, the UK and Australia? For example, Zopa in the UK with £1.6 billion of loans, Funding Circle with £1.4 billion of loans, and Lending Club in the USA with $20 billion of US dollars of loans, all of which charge borrowers origination fees, which is the subject of the Commerce Commission's investigation.
The Honourable Paul Goldsmith.
Because I think the laws relating to credit contracts are slightly different in New Zealand, and we have to deal with the situation that we have in this country and make sure that the laws work effectively. We do certainly want to see peer-to-peer lending work effectively in New Zealand, and I'm carefully considering the options to make sure that that works in practice.
Supplementary question, David Seymour.
How is New Zealand really different from the UK, the US and Australia? And is this a case of New Zealand companies falling behind because of poor, slow and not fit for purpose regulation, killing entrepreneurship in our fintech sector?
The Honourable Paul Goldsmith.
Mr. Speaker, I think the member could reflect on some of the ease of doing business in terms of regulation in this country where we score very highly. The member and his caucus may prefer no regulations, but we've seen that throughout history of the financial markets in New Zealand and globally that they can create problems. Are working through this carefully and sensibly.
Order. Point of order, David Seymour.
The Minister didn't actually address the question about this particular area of regulating peer-to-peer lending at all. He merely referred to peripheral issues.
The difficulty was it wasn't a very clear question the way it was answered. How is the New Zealand different from the UK, etc. UK, US and Australia. It was a difficult question, and I think on this occasion the Minister addressed it.
Supplementary.
Supplementary question, David Seymour.
Does the Minister find it odd that his government spends so much time trying to pump up economic diversification, and as soon as the private sector gives us some diversification, his regulatory regime kills it, as it is 45 employees at Harmoney and Parnell right now?
The Honourable Paul Goldsmith.
Mr. Speaker, I do agree with the member that the regulatory framework for peer-to-peer lending does need to be clear, and we do want to support innovation and competition in credit markets, and that's why we're giving this very careful consideration.
A supplementary question, David Seymour.
In light of that, will he consider clarifying the law by making a small amendment to the Credit Contracts and Consumer Finance Amendment Act, or will he let this overzealous regulator harm a nascent fintech industry in New Zealand?
The Honourable Paul Goldsmith.
Mr. Speaker, I'm not sure what the member is implying as to whether, as a minister, I should be interfering with the independent regulator in terms of the Commerce Commission, which I certainly wouldn't want to be doing. But we are giving thought to the broader policy issues.
Order. Point of order, David Seymour.
Mr Speaker, robust debate, but for Ian Lees-Galloway to infer that those questions were paid for by somebody outside the House is completely out of order. It brings disrepute to the House and he should stand, withdraw and apologise.
Yeah. Order. I heard the comment. I didn't actually identify who said it. Now that the person has been, I do require him to stand, withdraw and apologise.
I'll withdraw and apologise.
And that concludes questions for oral answer.